Estate planning is the process of putting together effective legal documents so that what you want actually does take place. I remind people that we all have wishes and wants. I don't want my kids to fight. I don't want my son-in-law to get anything. But what you want and what you get will vary based on what you do. And so we do have the ability to put a plan in place. So let's talk about some of the options. Some people's estate plan consists of this. Every year you say, well, didn't do it last year. I'm going to do it this year, until next year when you say it again. And it's just a series of kicking this down the road. If you die without a plan, and I mean no will or no trust, that is called dying intestate. And when you die without a plan, folks, you do get a plan. It is called the government plan. And the state in which you died, in our case, the Commonwealth of Virginia, would create a will for your family after you're gone. This new government-written will has to go through a legal process called probate, where the assets will be tied up in the courts, and the family has the opportunity to get together and argue over the things you left. There are two things that I'm pretty sure you don't want. You don't want to send your family to court, and you do not want the government to write your will. You see, when the state writes the will for someone who died without a will, the state does not know any of the family details. The state would not know that Susie already got her inheritance, that Jimmy hasn't talked to Dad in 10 years, that Barbara never paid back those loans. But you know who does know the family issues? The family knows. So when they get together in the courtroom, it sometimes sounds like this. Your Honor, yeah, this will you guys came up with? Not even close. She shouldn't get, he already got, Mom wanted me to have, and guess what they do in the courtroom? They fight. Do you know who wins that fight besides some local attorney and the state? Who often wins that fight is the one that hired the better attorney. So Jimmy, the more clever son, hires a good lawyer, and when that all settles out, he gets more of the estate. The worst part about letting the family work it out, in some cases fight it out if you die without a will, is very often the family does not talk to each other, and I mean sometimes for decades, because of what she got away with or what he tried to get away with. So the do-nothing plan, I will admit, is the least expensive plan available for you today, but it is the most expensive plan for your family. You don't want to go out without a plan. Okay, what can I legally do to prepare for my departure? You could do something called the last will and testament. A will is basically a set of instructions that says, when I die, I would like these things to go to these people. But what you may not know is that a will has to go through probate. Whether you write the will or the state writes the will for you, wills are probated. They go before the court. Now, I'm going to explain where the word probate comes from, because we're going to talk about that briefly today. But the word probate comes from an old Latin word, probare, which meant to test or to prove or to challenge something. What is being tested or challenged in the probate court is the will. Sometimes it's the will itself. That doesn't look like Dad's handwriting. I'm not sure he signed that. Maybe Jimmy made it after Dad died. Or maybe they're questioning the mental stability of the person that wrote it. Oh, Mom was saying all kinds of crazy stuff at the end. I'm not sure she was mentally competent to draw up the document. There's challenges against the will, there's challenges, but the underlying problem is people don't like what the document says, and so they complain about it. I thought I was going to get expectations and so forth. Now, so the will creates a scenario where it doesn't get around probate. It has to go through the probate process. Wills are a set of instructions, but they are not binding, and they can be challenged by others. A will, by the way, does not help us at all if we become incapacitated, because a will does not go into effect until you are dead. So a will is an option, but it's a very narrow option. It doesn't avoid probate. It has to go through probate. It's a set of instructions, but it's not binding. It can be challenged while in court. And it doesn't protect us at all if we get Alzheimer's, dementia, a stroke. If you lose mental capacity, the will has not gone into effect. There's no benefit for you in that case. There is a better option that is available to all of us. It is called the revocable living trust. The living trust is a legal document that allows us to transfer our assets to our heirs when we die without courts, without probate, without delay, And most of the time, folks, if we do this right, without the family fighting. Because unlike a will that can be challenged and argued about, the instructions in your living trust when you die are binding. It's basically you're saying to the kids, well, here's what you get. Whether you like it or not, that's optional. You're getting this percent or this asset or this property, but it's not subject to debate like a will. The living trust not only makes a smooth transition of our assets to our heirs without the courts, without government intrusion, the living trust, folks, does take care of us while we are living, because in the living trust are what we call incapacity documents. I often tell people to think of a trust as a series, a portfolio, we call it, of multiple documents. There is the trust that deals with distribution, but there's also the incapacity section. Who's going to help me if I'm impaired? It could be, again, Alzheimer's, dementia, a massive stroke, a car accident, you're rendered mentally incompetent. Well, in a trust package, you're going to get powers of attorney over financial and legal matters. There's also a power of attorney over health decisions. And then there's also something called the living will. Now, the living will is often referred to as the advanced medical directive, and that is what would you want to have take place if you're on life support, a feeding tube, a respirator? How would you like to be taken care of in that circumstance? Does anybody here remember the name Terry Schiavo, the girl in Florida, where for 15 years in court they argued over a feeding tube? The husband said, because she was vegetative, she wouldn't want to live like that. We're going to say goodbye. And the parents said, hold on, we think Terry's still there. And they went from this court to that court to this court for 15 years in court over a feeding tube. Do you know who eventually decided her fate? The state of Florida. That's right. And here's the important part about that. It is not because Terry had no wishes. It's because Terry had not expressed her wishes in writing in time. So I hate to be so blunt, but it's absolutely true. It's not going to matter what you want. It's going to matter what you wrote. Did you put your wishes in writing? Very important. Now, I like to break words down, like the word probate comes from the word probare, to challenge, to test something. The phrase power of attorney, the word power just means authority. Who are you authorizing to act for you? And the word attorney here does not mean someone that went to law school. It means advocate. Who would you want to be your advocate? Whether it's financial and legal matters with the general power of attorney, or the more specific power of attorney, the health or the medical power of attorney. Now, I happen to have some pretty good choices. Now, my first choice is a choice that some of you have in this room, and that is my spouse. I've been married to Christy for 35 years. She's been married to me for 35 years. She's my power of attorney, and I'm her power of attorney. But what if my wife and I were to get into a car accident, and in the accident, I become impaired, but she dies? I now need a power of attorney, and the person I selected, unavailable. So when you name your first power of attorney, that is your primary choice, always name alternate A and alternate B. Why? Because you have no guarantee who's going to be there to assist you. They might be in the same place or in worse shape than you are. So you need to pick a first choice and a second, and then hopefully a third. Now, I happen to have some pretty good choices. I have 4 adult children. I have a daughter that can tell you how much money she has in every account and how much she's saving for Christmas. She's good with money, you know. I have another daughter, and so when it comes to our power of attorney for financial matters, she's the one right behind the spouse. Spouse first, and then that daughter would be the next one. I have another daughter that's a nurse that wears scrubs every day and works in a hospital environment. So when it comes to healthcare decisions, she's the natural choice, and she's the alternate to each other. So you have to think, who would do a good job? Now, you may not have a nurse or someone that's good with money in your family, but I do try to remind people, if your son is lousy with his money, guess what? He'll probably be lousy with your money. So you have to think, who would do a good job for me? Who has the aptitude or the skills to manage money or is good under pressure for healthcare decisions and so forth?